shoes. Recorded live.
I'd like to welcome everyone for this Wednesday, February 12th edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Welcome to I'm Just a Crier in the Wilderness, and hear ye, God's court is now in session for repent, for the Lord's kingdom and its enforcement is near. Welcome to the revival of the study of equity, its principles, doctrines, and rules of equity in opposition to the tendency giving an undue prominence and superiority to purely legal rules, and ignoring, forgetting, or the suppression of equitable notions. We left off on section 1044, the second on constructive trust, and that's on page 277 in the PDF or page 2370 in the book. That's section 1044, picking up on constructive trust. So take notice and acknowledgement with agreement that this show under documents is a confidential arrangement not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic and informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state. It has not given any legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in preparation of use of herein referenced. It has no interest in any use referenced therein, is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons between the parties and the communications. By reading and using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and the show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $200 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Now, what is equity? And equity is defined by John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4, which states, my favorite quote, "Law is nothing without equity, and equity is everything, even without law." Just that one beginning sentence right there. If you understand what that means and all its ramifications, you've got it down. Continuing on, those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Soul and spirit of the law. Positive law is construed and rational law is made by it. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. So remember, it doesn't matter how many people don't believe something. What matters is whether it's true or not, what they believe. Now on to the pet peeve of mine, which is people can't discern what's public versus private. They don't really understand what really is private. So a good starting definition is private is any relation that you imply or express which is your intent as a special one. And the next question is, when did you ever express your intent to form any relation as a special one? And what is this special one we're talking about? Well, the answer is really never. So consequently, all your relations are all public, you just don't know it. This special relation, this is how we do it under NTT, and it's a private trust, and you just can't say, well, this is a private relation. That's not how you do it. That just doesn't make it so. Just because I declare the sky purple doesn't make it so. Just because I declare this to be a special relation doesn't make it so. It has to be something done specially to make it so. And what is this special? That's what NTT is all about. So then if it's never, then all your relations are all public, you just don't know it. And I like to use the example of talking to somebody across the fence, your neighbor in your backyard. You think it's all private? No, sorry, it's not. It's all public. You've done nothing special to form a private trust, and therefore your intent is not just a special relation, a trust relation, it's a public relation. So all your relations are then consequently all public and just don't know it. That brings in the doctrine of election. That's in section 461, I believe, in Pomeroy, where you have a multiplicity of choices of two or more, and the thing that you choose substitutes for all the rest. Or, in other words, you waive all the rest. It comes down to the intent, implied or expressed, on this special relation. And intent brings in this 2011 case out of the Courts of Appeals of Maryland, 2011 case. And it's quoted on Austin Wakeman Scott, Law of Trust, section 2.8. Says to be noticed that an express trust may arise even though the parties in their own minds did not intend to create a trust. And that's kind of confusing. Well, if you didn't intend to create a trust, then how could you create one? Continue on. It is the manifestation of intention that controls and not the actual intention. Manifestation of intention versus actual intention. Manifestation of intention, that's your actions written down on a piece of paper, which we call our deed. And then we assume that that piece of paper is a deed of ownership. No, it's only a recording of the act done. And what was the act done? Because that's the real thing. But it says it's the manifestation of intention, or the record, that's what controls. The record is of the action that was done, not the actual intention. Not having actual knowledge that I was creating a trust. It says it is the manifestation of intention that controls and not the actual intention, where that differs from the manifestation of intention. An express trust may be created even though the parties do not call it a trust and even though they do not understand precisely what a trust is. So you don't have to have actual knowledge of what a trust is to form a trust. Because it is sufficient of what they appear to have in mind is in its essentials what the courts mean when they speak of a trust. But imagine what you could do if you understood all about trusts. Because now you kind of get a glimpse of how easy it is to enslave everybody in some kind of obligation or duty as being trustee, and they don't even know they're trustee. They don't even know it's a trust. It is sufficient of what they appear to have in mind is in its essentials what the courts means when they speak of a trust. And the court is going to apply the trust test. Trust test is number 1, purpose, 2, intent, or really it's intent and purpose, 1 and 2. Parties, then there's only 3 parties in a trust, no others. They're called office heads. The office of grantor, the office of trustee, the office of beneficiary. There's only 3 offices in a trust, no other. No executor, no other agents, nothing like that. The 3 primary parties are grantor, trustee, and beneficiary. Those office heads are the 3 and only that are interested, that are having the nexus of the primary relationship. That's primary. Primary has priority. Any other relationship formed with any of those other parties, with say an executor or an agent, would be a secondary or derivative and does not have priority over the primary. So you've got intent, purpose, parties, now specific trust res, identifiable, and the last would be some method of formation. Say, a method of delivery. It is sufficient of what they appear to have in mind as essentials what the courts means when they speak of a trust. Trust is going to be, the court's going to apply the trust test. If it passes the trust test with all the elements necessary, then you got a trust. Now, to enforce a trust, you'd have to obviously know that it was a trust being formed, and you'd have to come at it as enforcement under trust law, which is in equity, not at law. And you'd have to know that there were 2 separate jurisdictions, not at law, single one. No, there's another jurisdiction called equity, and equity is the priority one. Decatur Act and rules of courts, usually in the scope and title of the first rule, spell it out that it's the substance that has the priority, which is equity, and it's the substantive is what needs to be done for a just and speedy and inexpensive remedy. And that the rules of the court is just the guides to the substantive being done. But everybody pleads with the technicalities of the procedures and processes and skips the substance. They don't know how to file in the right jurisdiction, and they don't know how to plead in that jurisdiction. And frankly, most of this is probably too hard for most people, only because they just don't want to. And they all want their rights as substantive rights, but yet they are not willing to learn what is necessary nor fight for their own rights. And consequently have none. That takes us to Adams' quote, Origin of English Equity. Because equity is the main thing, just like a Bouvier's quote. Where Adams wrote, we may confidently assert that equity and common law originated in one and the same procedure. And the reason why was because they didn't know the difference. They thought they were all one. Continuing on, that during the first 200 years of their history, in other words, in the beginning, they were not distinguished from one another. And that if we now distinguish between them during that period, we do it artificially between the application of tests impossible to contemporaries. It's well on to the 14th century before we get any clear distinction between equity and common law. It took them that long to figure it out. And what they figure out, well, equity is a separate jurisdiction from common law. Equity is what created common law, just like Bouvier says. It creates all the law. So that isn't the real law the principles in which all the other jurisdictions are formed? And what is the so-called law today? Boils down to, it's just like the jurisdiction of the so-called law or at law is just the judgment side of not living an equitable life. At least it should be. But if it's being interpreted wrongly instead of the broad interpretation, it's now the narrow interpretation, then you've got the wrong administration of the laws, or the laws are being taught wrongly. All this stuff shouldn't be so hard, but yet it is. Why do we have 63 million laws? God only gave us 10 commandments, 10 statutes and codes to live by. Why do we have 63 million of them that seem to be totally worthless and don't work anyway? I'll tell you why. Because we forgot the connection to the principles, maxims of equity. Equity is the priority. At law, statutes and codes, 10 commandments, that's just judgment. Judgment of an iniquity that's been done. Section 1044, second, constructive trust. Page 277. Section 1044, second, constructive trust. Constructive trust include all those instances in which the trust is raised by the doctrines of equity for the purpose of working out justice in the most efficient manner. There's your scope and title again, right there. There's your substance. There's the meaning of the law right there. It's so that the doctrines of equity, for the purpose of working out justice in the most efficient manner. There's your just and speedy and most inexpensive. Then it boils down to how are you enforcing it. Is it illegal to pull the ox out of the pit on the Sabbath? Or is it just and right to do that? Do I have to plead an exception? Or should the exception be the rule? How are we interpreting the law? Is it right to give the guy a ticket because he came to a rolling stop at the stop sign, but yet there was no accident caused, which would be the substance of the law? Well, you would say, well, it's good that we put a stop sign there because this is a high accident area and everybody needs to be reminded. Yeah, but he didn't come to a complete stop. I got to give him a ticket. He broke the law, the literal interpretation of the law. But was the substance done? Was there an accident caused? Does he say that he looked both ways, he didn't see anybody coming, and he just didn't completely stop, but he didn't cause an accident? Or did he say, well, I just, didn't pay any attention, I just went through the stop sign anyway? Well, that would make him guilty. The law for the stop sign is probably just because it's a high accident area, not to cause an accident as a reminder, but how is it being enforced? Back in the text, where there is no intention of the parties to create such a relation, and in most cases contrary to the intention of the one holding the legal title, and where there is no express or implied written or verbal declaration of the trust, says they arise when the legal title to property is obtained by a person in violation, express or implied, of some duty owed to the one who is equitably entitled, beneficiary in other words, and when the property is thus obtained is held in hostility to his beneficial rights of ownership. As the trusts of this class are opposed by equity, contrary to the trustee's intention and will, upon property in his hands, it is often termed trust in victum, and thus phrase furnishes a criterion generally accurate and sufficient for determining what trusts are truly constructive. An exhaustive analysis would show, I think, in all the instances of constructive trust, properly so called by may be referred to what equity denominates fraud, either actual or constructive, as an essential element, as their final source. Even in that single class where equity proceeds upon the maxim that an intention to fulfill an obligation should be imputed, and assumes that the purchaser intended to act in pursuance of his fiduciary duty, the notion of fraud is not invoked simply because it is not absolutely necessary under the circumstances. The existence of the trust in all cases of this class might be referred to constructive fraud. Footnote 1. As I refer to this class of cases where the trustee uses trust funds to pay for property purchased in his own name, equity assumes that he intended to act in accordance with his fiduciary duty, although in the majority of all instances the actual intention is undoubtedly to violate the duty. It has been seen that, in my opinion, certain kinds of so-called trusts, which are often spoken of as constructive, do not at all belong to this class. Back into the text. This notion of fraud enters into the conception in all its possible degrees. Certain species of constructive trust arise from actual fraud, and many others spring from the violation of some positive fiduciary obligation. In all the remaining instances, there is latent, perhaps, but nonetheless real, the necessary element, that of unconscientious conduct, which equity calls constructive fraud. Of course, of equity, by thus extending the fundamental principle of trust, that is, the principle of division between the legal estate and one of the equitable estate and another, and then we carry that to the extreme. We've caused the division and total segregation of no connection between equity and at law. Like the beneficiary can't be seen at law. No, that doesn't sound right. He can only be seen in equity. Why? Why not? Why can't the law recognize the true owner being the beneficiary at law in the at-law jurisdiction as well? Oh, no. We got to keep the ox in the pit. It's the Sabbath. Got to maintain the segregation. So all cases of actual and constructive fraud and breaches of good faith are enabled to wield the remedial power of tremendous efficacy in protecting the rights of property. They can follow the real owner's specific property and preserve his real ownership, although he has lost or even never had the legal title, and thus give remedies far more complete than the compensatory damages obtained in courts of law. See, equity is very flexible, its principles, and the principles can be applied just in any situation, into any jurisdiction, for any circumstance. Law has to be spelled out exactly. Equity doesn't have to. That doesn't mean that the judge has total discretion. The train only runs on the track, and if the track doesn't run to a certain city, the only way it's going to get there is by derailment. The principle is one of universal application, extends alike to the real and to the personal property, to such things in action and funds of money. Salutary and efficient as the principle is, However, many of the constructive trusts which it creates are only trusts sub modo, and that they have little resemblance in their essential nature to express trust. Footnote 3. Case cites that supports that. It says a case was one where a person had fraudulently obtained trust property, but the remark will apply to all such constructive trust based upon actual fraud. When it is said that the person who fraudulently receives or possesses himself of trust property is converted by this court to a trustee, the expression is used for the purpose of describing the nature and extent of the remedy against him, and it denotes that the parties entitled beneficially have the same rights and remedies against him as they would be entitled to against an express trustee who has fraudulently committed a breach of trust. Back into the text. In applying this principle, care should be taken to distinguish between actual trust and those relations which are only trust by way of metaphor, between persons who are true trustees holding the legal title for a beneficial owner and those who simply occupy a position which is analogous in some respects to that of a trustee. In other words, they're different relationships that look very similar to trust, but they lack one of the more necessary elements to form and qualify it as a trust, and therefore it's strictly DC. The use of these terms to designate relations and parties which have no essential element in common with actual trust and trustees can only produce confusion and inaccuracy. Next section, 1045, kinds and classes. The specific instances in which equity impresses a constructive trust are numberless as the modes by which the property may be obtained through bad faith and unconscientious acts. It is possible, however, to distinguish and describe the general groups or types under which all these instances may be arranged, and thus to present a comprehensive view of the whole subject. But how would you know what an unconscientious act would be? Does not everybody really know in their heart what's right and wrong? But, you hear that and it's like, oh, that just doesn't sound right. That's not fair. That's not just. That's not right. You want to know why that is? Because God wrote that on your heart. He didn't write the 10 Commandments on your heart. He wrote the meaning and understanding of equity. Equity's been written on your heart, not the 10 Commandments. Everybody knows what's being done to them, whether it's fair, just, or right. The thing is, you got to recognize you got to be doing that to others. And that's very difficult for people to do. First, you got to recognize that has to be done, and you have to be doing that first. He who comes into equity must be doing equity. Unless you're living an equitable life, do you expect God to do anything for you? When you come into His court of equity and ask Him to do something for you, it ain't going to happen. The Old Testament's full of examples of disobedient Israel. Although God was very gracious in leading them to do what was right, in the end, He had to punish them. He hauled them up into captivity, killed many. Hear, O Israel, hear, the Lord thy God is one. He never changes. He's from the beginning to the last, the same. Chapter 15 in Matthew says, hey, you Jews and Pharisees, you're teaching the laws wrong. You got the wrong interpretation. He wouldn't leave the ox in the pit, even if it was a Sabbath. He didn't wash his hands either when he ate. He healed on the Sabbath. He didn't go by the same laws the Jews went by. So consequently, they didn't believe that He was from God. But here all along, they had the wrong understanding, the wrong enforcement, the wrong interpretation. the wrong teaching of the law. They'd forgotten about equity. Same thing today. And it's not just them, it's us. We are the guilty parties, each and every one of us. We don't do equity first to our brothers. But when something dreadful happens to us, we want God to help us. It is possible, however, to distinguish and describe general groups or types under which all these instances may be arranged, and thus to present a comprehensive view of the whole subject. Next section, 1046, number 1, arising from contract, express or implied. There are certain relations which are often spoken of as trusts, and as constituting the species of constructive trust, but which are not, in any true and complete sense, trusts, and can only be called so by way of analogy or metaphor. Since they lack the element of fraud, they do not, in any view, properly belong to the division of constructive trust. Footnote 1 says there is a tendency among writers to enlarge the meaning of the word trust beyond its legitimate signification, and by some the various equitable liens and similar rights arising from contract are made to be the most important. Contracts are made to be the most important, and with a very few exceptions, the only instances of constructive trust, as Lord Wellesbury shows that such a mode of treatment can produce nothing but confusion. Sounds like today. The cases included in the first subdivision of the text are not constructive trust, and they are mentioned by simply for purpose of completeness and to distinguish between correct and mistaken conceptions. Back into the text, it's commonly said that a trust is created by a contract for the sale of land, that the vendor holds the legal title as a trustee for the purchaser. Whatever of the truth it is in this mode of the statement, whatever the real trust relation exists, it certainly has nothing in common with constructive trust. It rather resembles an express trust. In like manner, the survivors of a partnership are called trustees for the estate of the deceased partner with respect to the share of the firm property. This expression is mostly metaphorical and is certainly nothing in relation and resembling a constructive trust. Extending the analogy still further, courts regard partnership property after an insolvency or dissolution of the firm and in the proceeding for winding up its affairs as a trust fund for the benefit of the firm's creators. And a capital stock and other property of private corporations, especially after the dissolution, is treated as a trust fund in favor of creditors. These statements may be sufficiently accurate as strong modes of expressing the doctrine that such property is a fund secretly set apart for the payment of partnership and corporate creditors. Before it can be appropriated, the use of the individual partners or corporators, that the creditor have a lien upon it for their own security, but it is plain that no constructive trust can arise in favor of the creditors unless the partnership or directors, through fraud or breach of fiduciary duty, wrongfully appropriated the property and acquired the legal title to it in their own names, and thus place it beyond the reach of creditors through ordinary legal means. I have thus collected the instances which are sometimes, although improperly classified with constructive trust, in order for more clearly to indicate the nature of trust which are clearly or truly constructive, and which are described in the following paragraphs. Next section, 1047. Number 2, money received which equity belongs to another. By the well-settled doctrines of equity, a constructive trust arises whenever one party has obtained money which does not equitably belong to him, and which he cannot in good conscience retain or withhold from another who is beneficially entitled to it, as, for example, when the money has been paid by accident, mistake of fact, or fraud, or has been acquired through a breach of trust or violation of fiduciary duty, and the like. It is true that the beneficial owner can often recover the money due to him by a legal action upon an implied assumpsit. There's legal action upon an applied assumpsit. So assumpsit is legal action. in many instances, a resort to the equitable jurisdiction is proper and even necessary. 2B. Next section, 1048. Number 3, acquisition of trust property by a volunteer or purchaser with notice. Whenever property, real or personal, which is already impressed or with or subject to a trust of any kind, expressed or by operation of law, is conveyed or transferred by the trustee, not in the course of executing and carrying into effect the terms of the express trust, or devolves from a trustee to a third person who is a mere volunteer or who is a purchaser with actual or constructive notice of the trust, then the rule is universal that such heir, divisee, successor, or other voluntary transferee or such purchaser with notice acquires and holds the property subject to the same trust which before existed and becomes himself a trustee for the original beneficiary. Equity impresses the trust upon the property in the hands of the transferee or purchaser and compels him to perform the trust if it be active, and to hold the property subject to the trust, and renders him liable to all remedies which may be proper for enforcing the rights of the beneficiary. It is not necessary that such transferee or purchaser should be guilty of positive fraud or should actually intend a violation of the trust obligation. It is sufficient that he acquires property upon which a trust is in fact impressed, and that he is not a bona fide purchaser for valuable consideration without notice. This universal rule forms the protection and safeguard of the rights of beneficiaries in all kinds of trusts. It enables them to follow trust property, lands, chattels, funds, of securities, and even of money, as long as it can be identified in the hands of all subsequent holders who are not in the position of bona fide purchaser for value without notice. It furnishes all those distinctively equitable remedies which are so much more efficient in securing the beneficiary's rights than a mere pecuniary recovery of the law. Even when the original property is placed upon the reach of the beneficiary by sale to a bona fide purchaser for value without notice, a trust, as will more fully appear hereafter, attaches to the proceeds in the hands of the trustee who makes the transfer. The statement and grounds of the rule show that it does not extend to the case where the property is duly transferred or purchased in pursuance of an express trust to convey or sell and for the purpose of carrying out such trust into effect. And where the rule does not apply, there is some distinction between money and other kinds of trust property. If a trustee or a fiduciary person, in violation of his duty, uses trust money to pay an antecedent debt of his own to a creditor who has no notice of a breach of trust, or that the money is subject to a trust, in such a manner that the money is received as a general payment and not as a distinct and separate fund, then the money becomes free from the trust and cannot be followed by the beneficiary into the hands of the creditor, although in general an antecedent debt does not constitute a valuable consideration. Footnote 2D says, the reason for this conclusion is the money is not earmarked when received by the creditor and mingled with his other pecuniary assets. It cannot be distinguished and identified, and under these circumstances, other kinds of property would remain subject to the trust since the creditor would not be a bona fide purchaser for value. Case cites to support that. Back into the text. Next section, 1049. Number 4, fiduciary persons purchasing property with trust funds. Another important form of trust arises from the acts of persons already possessing some fiduciary character or standing in some fiduciary relation. Whenever a trustee or other person in a fiduciary capacity acting apparently within the scope of his powers, that is, having authority to do what he does, purchases property with trust funds and takes the title thereto in his own name without any declaration of trust, a trust arises with respect to such property in favor of the city key trust or other beneficiary. Equity regards such a purchase as made in trust for the person beneficially interested, independently of any imputation of fraud and without requiring any proof of an intention to violate the existing fiduciary obligation, because it assumes that the purchaser intended to act in pursuance of his fiduciary duty and not in violation of it. This doctrine is of wide application and extends to the trustee, executors, and administrators, directors of corporations, guardians, committees of lunatics, agents using money of the principals, partners using partnership funds, husbands purchasing property with money belonging to a separate estate of their wives, parents, and children, and all persons who stand in fiduciary relations towards others. Equity jurisprudence contains few more efficient doctrines than, thus, in maintaining the beneficial rights of property. The evidence that the purchase was made with trust funds must, however, be clear and unmistakable. Section 1050. Number 5, renewal of leases by partners and other fiduciary persons. Another special form of constructive trust, depending upon much more general principle to be examined in subsequent paragraphs, has been established by unanimity of decisions. One member of a partnership cannot, during its existence, without the knowledge and consent of its co-partners, take a renewable lease in his own name or otherwise for his own benefit and thus to the exclusion of his fellows, of premises leased by the firm or occupied by them as tenants. A lease so taken by a partner inures the benefit of the whole firm and is regarded as the continuation of or as grafted on in the old lease. A trust will be impressed upon the leasehold estate. Equity will treat the partner as a trustee for the firm, and if necessary and possible, will compel him to assign the renewal lease of it. If a condition inserted in such a lease against the signing would prevent the relief of an actual assignment, it will not in the least prevent the court from enforcing the trust by compelling the partner to hold a legal title for the benefit of all. This rule applies under very variety of circumstances, provided the rights of the other persons or partners and are still subsisting at a time when the renewal lease is obtained. It operates with equal force whether the renewal lease was to begin during the continuance of the firm or after its termination, whether the partnership was for an undetermined period or was to end at a specific time and the renewal lease was not to take effect until the expiration of a prescribed time, whether there was or was not a right in the firm by contract, custom, or courtesy to the renewal of the original lease from the leaser, and even whether the landlord would or would not have granted a new lease to the other partners or to the firm. All these facts are wholly immaterial to the application of the doctrine, for it's, I might add that it would probably be also not legal, but it would not be inequitable. Back in the text, for his operation does not in the slightest degree depend upon the terms and provisions of the original lease, nor upon the attitude of the landlord. The doctrine is not confined to partners, it extends in all its breadth in with all its effects to trustees, guardians, and all other persons clothed with fiduciary character who are in possession of premise as tenants on behalf of their beneficiaries, or who are in possession as tenants of premises in which their beneficiaries are interested. Now, that might kind of shed light on why in your deeds it says, tenants on it. Back in the text, as this rule results from the relation of trust and confidence existing between the partners or other persons interested, it might be regarded as an outgrowth of the doctrine formulated in the preceding paragraph. It is more directly, however, a particular application of the broad principle of equity extending to all actual and quasi-trusts or trustees, and as that a trustee or person clothed with a fiduciary character shall not be permitted to use his position or function so as to obtain for himself any advantage or profit inconsistent with the supreme duty to his beneficiary. Next section, 1051. 1051, number 6, wrongful application of conversion into a different form of another property. In the foregoing fourth form of constructive trust, the fiduciary person appropriates trust funds in the purchase of property, but the court imputes no wrongful intent. It assumes that he was acting in pursuance of his trust. In the present case, the wrongful intent necessarily exists. The intended violation of fiduciary duty and of other beneficial rights is the essential element. A constructive trust arises whenever another's property has been wrongfully appropriated and converted into a different form. If one person having money or any kind of property belonging to another in his hands wrongfully used it for the purchase of lands, taking the title in his own name, or if a trustee or another fiduciary person wrongfully converts the trust funds into a different species of property, taking to himself the title, or if an agent or bailee wrongfully disposes of his principal securities with the proceeds purchases other securities with his own name, and in these, all the similar cases, equity impresses a constructive trust upon the new form or species of property, not only while it is in the hands of the original wrongdoer, but as long as it can be followed and identified in whatsoever hands it may come, except to those of a bona fide purchase for value without notice. The court will enforce the constructive trust for the benefit of the beneficial owner or original sedicee trust who has thus been defrauded. It is a necessary consequence of this doctrine whenever property subject to a trust is wrongfully sold and transferred to a bona fide purchaser so that it is freed from the trust, the name of the trust immediately attaches to the price or proceeds in the hands of the vendor, whether such price be a debt yet unpaid due from the purchaser or a different kind of property taken in exchange, or even a sum of money paid to the vendor, as long as the money can be identified and reached in his hands or under his control. It is not essential for the application of this doctrine that an actual trust or fiduciary relation should exist between the original wrongdoer and the beneficial owner. Whenever one person has wrongfully taken a property of another and converted it into a new form or transferred it, the trust arises and follows the property or its proceeds. Now, let's suppose we trace the title back to land and we come back to the first one. First transfer the property. Did that first transfer take place with true ownership? In other words, can a person transfer something, some kind of rights that he does not have? And the answer to that is no. You can't transfer rights that you don't have at the time of the transfer. So, the original transfer, the first one, where did that person get ownership? Can that person prove ownership? Because I'd like to know where God gave that person a transfer in writing. So if that person does not own true ownership of the property, what is he transferring? Just possession. Because he's using the property. You see, today there are no ownership titles because the whole planet, Earth, all of creation is God's. And nowhere in the Bible has ownership transferred to man. He has a trust duty of possession and use. So how can you charge me for a transfer of ownership which you don't have? Who owns the property, even what you're in possession of today? Not you. It's God. He's the grantor of it. It's for him as beneficiary. You and I are just trustees while we're here. And we don't have any rights to charge anybody because the land was granted to you for free. Freely you have received the land and everything that comes from the land, and freely you should give it without charge. That's the way God established it, and that's the way it should be administered until the end of the age. There is no commercial transaction necessary because there is no commercial transaction, period. Commerce is slowly there to enslave you and to be a millstone around your neck. And the fact that you are worshiping commerce by doing it, you have chosen this day the God you are following. And it's not God in heaven. It's the God of mammon, the God of commerce. You know, not many people can think, how can you operate without money? Oh, how would I buy my groceries? How would I get my gasoline? Well, we can't function without money. Why not? Wasn't meant that way to begin with. God didn't say to Adam, hey, Adam, I want you to tend the garden for $6.95 an hour. Didn't happen that way. The reason why you can't operate without money is because you never thought about it. And you're not asking God. You're not seeking and knocking and asking Him, how can we do this? That's the first thing you should do. Pray and ask. You do not receive because you do not ask. Jesus, through the temple, money changers out of the temple doing commerce in the Father's house twice. 2 different occasions. Even if it wasn't 2, if it was just 1, still the same principle. It wasn't that they were doing unjust weights and measures, which was one thing they were doing. No, they were doing money changing. That's commerce. There's no commerce in my Father's house. God's kingdom of heaven on earth does not operate by commerce. Doesn't operate with money. Money is Satan's device to enslave, to rob you blind, to get you to volunteer all your time for something worthless. That's the same MO that Jesus was tempted on the mountaintop when he was asked to bow down and worship me, and I'll give you all that you see. When all that he saw, he already owned and didn't have to give it up. He didn't fall for the trick. Adam and Eve did. Oh, look at the apple, how good it is for food. Here, let me give this to you, and I'll take all your rights from you in exchange. So section 1052. I think we'll stop there, pick up there next time. Section 1052. That's on page 308. That's section 1052, page 2401 in the book, or section 1042, page 308 in the PDF. So I'd like to make an announcement. We've talked about last week or the week before, alluded to this congressional act that was explaining that the birth certificate was a trust. And on further checking with it, we find out that this whole document is totally fake. It doesn't say that in that congressional act at all. Somebody wrote that up to match their stinking thinking and put it out there, and everybody's gobbling this thing up like wildfire. And here it is a bunch of lies. So it pays to check out your facts and make sure that you're operating in truth, or else you'll be believing on a lie. Now, that doesn't mean that the birth certificate is not a trust. It's just that that congressional act didn't explain it to be a trust the way it was worded. So that act that I mentioned last week or the week before, that's totally canceled. That is totally garbage. That act does not exist the way it is written. Find the original one and read it for yourself if you want to. That turned out to be non-verifiable. So let's open it up for Q&A. Press star 8. Star 8 to raise your hand and get in the queue line. Star 8 for anybody to ask a question. Star 8. State your name and where you're from. Star 8. Anybody? Questions? Star 8. Raise your hand. Hello. Anybody there?
Hello, Christian. It's Shaka from England.
Hi. How you doing?
Yeah, I'm fine. I'm fine. Yourself?
Back again, huh?
Yeah, back again. Yeah, I don't think you'll get rid of me now. So, yeah, I've got a few questions regarding enforcement and also some of the materials that we're reading. I was wondering, like if you're going for the enforcement on a breach of trust, if there's a workaround to using a notary mailing, because over here it's real difficult to get a notary to do anything, that's slightly unorthodox to what they're used to doing. So I was wondering, like if you had something delivered, whether it's by mail or by hand, if you had maybe two witnesses who were prepared to verify that with
Yes,
a sign.
Yes.
So, sorry, I didn't hear that.
Yes, you could do it that way.
Yeah. Okay. Yeah, I thought so. Yeah, I just wanted to run it by you.
You could also do it by, say, over here we have the sheriffs who serve legal documents, plus they have independent servers also.
Okay. That's something I'll look into a bit more then.
Because they just write an affidavit confirming that they delivered such and such a document. And that's basically all you really need. That creates the record that it's been delivered.
Yeah.
And all we're looking for is just two records to verify anything.
Okay. Okay. Um, on the more recent audios, you were talking about like calling a tribunal and granting authority to hear special matters.
Right.
Is that something that you just started talking about recently, or have you been talking about that for a while? Because I was trying to find more audios on that.
We haven't talked about that a whole lot. I know there's been several times when I've mentioned that. One time we kind of went over it in depth more, but we haven't really talked about it since then. Now,
Yeah.
what I was talking about was applied to just strictly federal, because the federal wasn't granted original jurisdiction.
Okay.
Now, I don't know about in each particular state how it applies on a state principle, but I would say usually the states follow the federal.
Mm.
And in your country, I'm not sure, but
Okay.
have to research it out more. But I know in federal that's the way it is in federal.
Okay. 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 Something I was thinking about before is that some of the materials that you've been suggesting that we read, like Gilbert's, Gibson's, Phelps, Pomeroy, Lewin's especially. I think those 5 are the main ones I've picked up
Mm-hmm.
on. Have you? I mean, obviously we're using those as kind of authoritative works to some extent, but have you found some shortcomings in those works or some errors that you might want to share with us? Or
Yes, I think that all of them have a commercial bent. They have a commercial bias because equity has come in and is being applied to the commercial realm, and I think that's an inappropriate use of equity, but that's what they're doing.
okay,
So I think that if you pull out all the commercialness out of what Pomeroy and all those guys talk about, you've got pure private equity.
okay, okay. So the nearest thing to private equity would be like the first few pages of Lewis, probably.
Yes,
But,
that one is solely pure trust. Yeah.
Yeah.
Although I think in Lewin does mention something about for the equity was formed for the or used to enforce the creditor getting his payment back. So
Yeah.
even back then they used it as a commercial sense.
Okay.
Because they look at it as equity can be so flexible, it can be used in any new creation of any new rights.
Mm.
And so they created this commercial realm, and they're applying equity to enforce it.
Yeah.
I think that's a wrong use of equity because this commercial realm wasn't really meant to be from the beginning.
Yeah. Yeah, I agree. I agree, but at the same time, what you just said, the fact that it can be used for, to come up with some remedies, if you want to use that word, for various problems that people have. I think from what I can make out, it's that seems to be something that people are struggling with in the study group, just kind of not getting it, not understanding the power of equity. And I mean, I've listened
we're
to you.
really trying to explain a whole jurisdiction that's been lost, and that's very difficult to do because it's very broad. Although the principles of what it's founded on are very simple. There's only like 13 maxims that runs the whole thing.
Yeah.
But the complexity of Pomeroy is, wrote, all these volumes according to the process and procedures of equity jurisdiction and its enforcement and all of, it gets kind of complicated. But you got to be able to, sift between all the garbage and just come to the bare essentials or the elements of the whole thing. And that comes down to what he explained in his preface of the whole series, which he said if you understand the principles of equity, that it's the maxims, and you get that, you've got it.
Yeah.
Because it's what he is based on what's fair, just, and right.
Yeah, exactly. I mean, I don't know exactly why there seems to be so many people struggling with it because to me it seems only a little bit of reading is enough to kind of get the point across. Like there's so many little references that we could pick up on, like something that was sent to me from what was this document? The origin of
trying to apply a simple a set of principles into a civil jurisdiction that's controlled by a lot of rules.
Yeah.
And we're trying to pigeonhole it in there. And that's the hard part. And we haven't found the jurisdiction how to quite turn the light switch of the jurisdiction on and off at will.
Mm.
So there's obviously some switches missing somewhere, or else we're not doing something quite right. And I think most of that is an application of commingling, because they're taking the DC realm statutes and codes and things and commingling it. And then once they do that, they breach, and it gets sucked back into the legal.
Yeah.
People are not pleading a purely equitable case. They're not going into a purely equitable jurisdiction. They're not filing a purely equitable case right. And I think that's what the problem is.
Okay. Mm.
DC brainwashing. They got to forget that stuff.
Yeah. Yeah. It's not easy, is it?
Equity is purely simple and reasonable.
Mm. Yeah. I think maybe in some ways it's too simple, like you say, because of the brainwashing.
Yeah, we make it too hard.
Yeah. Yeah. You've been taught to speak a complex language that now you can't even express yourself in the most basic way.
Correct.
Yeah. Yeah. Like for instance, the question that I asked you first about workarounds using the notary. I probably knew the answer to that question before I asked you, but because of a lack of confidence or lack of knowledge or whatever, I felt the need to ask you anyway. Do you know what I'm saying? It's the same kind of thing. It's like, why am I asking a question that I already know the answer to? Just because I feel like there's someone more knowledgeable than me that I need to confirm it on my behalf.
You're looking for confirmation, yeah.
Yeah. Well, yeah.
Two or more are powerful.
Yeah, yeah. I suppose that's what we're doing all the time. We kind of defer authority, isn't it? And then that's how they've got us.
Yeah, we transfer the authority and power to them, and then we don't know we did that, because that's the difference between a general deposit and a special deposit.
Mm-hmm.
We don't understand the nature of the deposits. When I do a special deposit, I retain the rights, and they've got possession of the title. Mm-hmm. Under a general deposit, I transfer everything to them, and I got no callback rights, anything.
Yeah.
And that's the difference between special deposit and general deposit. And everything is by default general deposit.
Mm-hmm.
Unless it's specially invoked.
Yeah.
That's the problem. Nobody knows that there is another jurisdiction of a special deposit trust enforced in a different jurisdiction with a rule set being different, being equity. Versus legal. That right there is a mind shake-up right there. That's like hitting a brick wall at 900.
Yeah, yeah. Because, I think, the natural instinct is that it would be the other way around, that, you're naturally operating in the private.
Yeah, it's tough
with
to
your
come
rights
to
intact.
the conclusion that you're dancing on a wrong stage, using the wrong tools. In other words, you're in the wrong jurisdiction.
Yeah.
You're trying to bring in substantive rights that can't be seen there, and you're trying to enforce substantive rights in a jurisdiction that can't recognize them. And you wonder why they can't see them. what you're asking for is in the other jurisdiction.
Yeah. Well, I mean, if people don't see it now these days with what's going on in the world, then I don't know if they'll ever see, because, I mean, some of the things you see going on with the banks, for instance, or just in the realm of finance in general, like in Greece, you know, people's assets being seized. If you've got over a certain amount in the bank, then they'll just take it. The bank will just take it. Or in the US, you know, people's pension funds being seized and things like that. I mean, that shows you clearly what the meaning of general deposit is. You know, you go and put your funds in the bank, then you've given it to them, and that's it.
Yeah, well, that's the contracts that we sign. And that's the manifestation of the record, the contract. And there's no other records that we have that we can prove anything otherwise. No other jurisdictional documents that we can prove it with, because we never created them. That's what NTT is all about, how to create records of another jurisdiction, how to create the special relation, and how to enforce it.
Mm-hmm. Yeah. Okay. Other questions that I have here. Yeah, I haven't got that much specific questions I want to ask, really. I just wanted to kind of see if maybe you could talk a bit more about the enforcement in terms of the tribunal, but maybe that's something I need to research a bit more myself to see exactly how it works over here. You know, like last time when I called last week, I was saying that the Chancery Court is in plain sight in the UK. I mean, what I meant by that is, you know, you can find out easily who the Chancellor is, you know, where the Chancery Court is and whatnot. And they've uploaded PDFs on websites where you can download various documents regarding procedure and different, you know, various information that maybe other people might be interested, even people in different countries might be interested to see. If you go into a search engine and just type in something along the lines of, you know, UK Chancery Court, you'll see loads of pages come up, and there's a lot of easily accessible information. So they seem to be quite helpful in that regard, to be honest. It's not like they're hiding too much.
Well, I don't think it's hidden here either. It's in the libraries. You just have to know that it's on a different shelf.
Yeah.
Nobody goes to those shelves. Everybody goes to the common law, civil code, you know, statutes and codes and things. You know, they're not looking in the right place. They're just following, you know, somebody else before them. They're just proceeding on in the same blind jurisdiction, at law.
Yeah.
Equity's there, alive and well. Hutchinson versus Maxi Center case spells that out here.
Yeah.
The distinction of their jurisdiction has been abolished, but under one civil action, that makes it look like it's merged. It hasn't been merged. They're still separate two jurisdictions. Equity separate from at-law jurisdiction. They could never merge them because they're going by two different principles or rules. The rule set in equity is the equity maxims. The rule set in at-law is case precedence. That's like oil and water. They don't mix. They can't merge them. They didn't. They did what was right. They didn't merge them. They made it one action, but they didn't merge it. But then I don't think they made it clear enough to tell you that they're still separate two jurisdictions. They don't tell you that.
Yeah.
That's like the ox leaving it in the pit because it's the Sabbath. You know, oh, we can't do that. The law says, you know, we can't preach from the bench and tell you about a jurisdiction. And we can't tell you, well, where you need to go to explain it. You know, you need to go to the library and look under the equities place.
Yeah. Well, I mean, you know, according to some of the information that we're coming across. It seems like, what is it, in the 14th century that there was some kind of distinction made. Before that, maybe they were just kind of operating hand in hand, equity and common law.
Yes, they were not distinguished as being separate.
Yeah.
That was the confusion back then. But that doesn't mean that they weren't separate. They've always been separate.
Yeah.
Equity is what created common law. It's just that we finally come into the realization that they are segregated. But they shouldn't be segregated to the fact that the common law should be the same as the statutes and codes, or the same as the Ten Commandments. And that's all the judgment side of not doing what was equitable.
Mm-hmm.
We really don't need the Ten Commandments, the statutes and codes, or common law. We just need the equitable principles and need people to be living by them. If we'd all treat each other fair, just, and right, there would be no need for any Ten Commandments, statutes and codes, or common laws.
Yeah. So, what do you think happened in the 14th century that caused some change? I mean,
God poured into man's mind the understanding that they were separate, and equity came more into their understanding, and we came out of the Dark Ages.
Okay.
The Renaissance was born, and people started acting more equitably. They started getting blessed more. Things blossomed and bloomed until now. Now we're going to reverse again.
No, it's backwards. Yeah. Okay. Well, I don't have that many questions today, so I'll get off for now. Maybe I'll come back on in a while if there's not that many callers.
Okay, all right.
Yeah. Okay. Okay. Thanks, Christian.
All right, thanks for coming on.
Okay. Okay.
Okay, who's next? Star 8 to raise your hand, anybody? Star 8, questions? You in the queue line? State your name, where you're from. We got a clear board? Clear board, there's nobody in line. Anybody question? Question, Star 8? Star 8, anybody? Question? Be a short night. Anybody? Question?
Yeah. Yeah. Christian, can you hear me?
Yes. Go ahead.
Yeah, Shaka again. Yeah, I just jumped back in because no one else is there. So, yeah, okay. In that case, I'll ask a little bit more. You know, in the past you spoke about having a lease account. I think. Did you refer to it as a 98 account or something like that? I think it's a lease account that would be associated with the private trust or the public trust that runs alongside the private trust for the benefit of the man. Is that right? Yeah. Yeah. What exactly would be the purpose of having a lease account?
Well, I don't know if I'd call it a lease account, but it was the 98 was a private. I forget what we called it there back then. It was.
Okay. Because I tried to do some research on that, and I was under the impression that these 98 accounts are some kind of lease account, but I wasn't too sure. That's why I'm asking. But
Yeah, I think that was the IRS recognizing a certain type of account and giving it a 98 description number.
Okay. Okay. Because I'm trying to get my head around, if I'm operating in a private capacity, and how to administer the trust without messing it up, without breaching my own trust. How exactly to go about dealing with banks and various entities, the private banking that I see, the information that they give, like say with the regular bank that I'm using now, for instance, they say they use some very strange wording, which is like contradictory at times. Sometimes they say that you need to have a certain amount, like say £3 million, for instance, before you're eligible to do private banking. And then sometimes they don't say that. They need to figure out.
Okay, is that really true private banking though? That's the thing. Or is that just the private side of the corporation? If a corporation is public, if it has a private side, then what is the private side of that corporation? It's still public also.
Mm-hmm. Yeah. So this is what I was thinking with
So in other words, what's its nature and its character? Well, its nature is still public, even though its character-wise is saying it's private.
Okay.
The nature that controls, it's still public. It's got a public nature, even though it's got a private side and character.
Yeah.
Where the true private side being equity in its nature and also private in its character.
Mm-hmm. But you could still deal with an entity such as that, a public corporation, and without breaching your trust, right? If you tread carefully.
Yeah, because it really comes down to the source of the credit. You can't tell what source the credit is because credit looks like credit no matter where it came from, private side or public.
Yeah.
It's all the same thing.
Okay.
So private source credit can't be distinguished in the public as being anything other than character.
Mm-hmm. Hello? You still there?
Yeah, still here.
Mm-hmm. Okay. Okay. Yeah. Okay, yeah. Some stuff I'm going to have to just go away and think about. What else was I going to ask you here? Now, when you, I just want to confirm something. When you nominate somebody as a trustee, am I correct in thinking as long as they're holding the reds, they can't disclaim, right? If they disclaim, they have to return the reds.
Yeah, they can disclaim, but if they are holding the res, the disclaimer, your actions speak louder than your words. They're acting like trustee by holding on to trust res. Even though they say, I'm not trustee, or disclaim.
Yeah. Yeah. So okay. So that answers my second question.
Actions speak louder than words.
Yeah. Yeah. So that answers my second question was going to be, if somebody, disclaimed so-called, but they were still holding the res, you could still just push on to the next stage of the enforcement and say, well, look, they're holding the res, so they are the trustee.
Yeah. Now I would also have been a vesting date. I would say on such and such a date, the trust vests.
Yeah.
Now they got the time period up to that point to disclaim properly, and if they don't, then the trust vests. And from that point on, then they're supposed to be doing the duty.
Yeah. And so a breach of trust would be anything that they're not doing that they were instructed to do. Absolutely anything that they were instructed to do that they're not doing. You could just come in harsh. Yeah.
Sure. Yeah.
Yeah. Okay. Okay. Yeah, I've got some other questions, but I'm not really happy with those. I want to think about them a bit more first before I ask you. So,
okay.
Yeah, I think I'll leave it at that for now.
All right.
Yeah. Okay then.
Thanks,
Christian. Thanks a lot. Yeah. Okay, no problem. Thanks.
Okay, next caller. Star 8, anybody? Question? Who's next? Nobody? Clear board? Anybody? Star 8 for question? Star 8, anybody? Question?
Hello?
Star 8.
Hey, how you doing, Christian?
Hello.
It's Chris from Maryland.
Hey, how you doing, Chris?
All right. I was just wondering if you could talk a little bit more about that section you were reading about not being able to transfer something that you don't have.
Yeah, it's just, it stands to reason if you think about it. If you don't have any right, how can you transfer something that you don't have a right to? So if you never had the right to ownership because you don't have an ownership title, then how can you sell up something that you don't own?
And so you said it's just for the use or the possession.
Yeah, so if God never granted ownership to any man and he retained beneficiary interest in himself to all property and entrusted it to man as being trustee, then how can we as trustee take and transfer ownership when we never had ownership title to transfer?
To begin with, okay.
Now, that brings in a lot of ramifications of things, Why isn't somebody sticking up for God?
It kind of makes you think of that, the scripture, the earth is the Lord's and the fullness thereof.
Yeah.
It all belongs to Him.
And if you think about it, you received all this free. And it says, freely you have received, freely give. So what we received free, which is, we came from the ground. Everything you use comes from the ground. Everything that's made is made from the ground. Therefore, you can't charge for it.
Right.
You don't own it.
Don't own it.
Just think of all the things that are made from the ground. Your cell phone, your computer, your furniture, your carpeting, your automobile, everything comes from the ground. How can you charge somebody for it? It's all supposed to be free. This whole nonsense of everything being commercial and its transaction is ludicrous. It's man's thinking. It's not God's principle. Never was from the beginning. Everything should be a totally free society. Everything that you got for free. It's just that you were duped into buying it. We could turn that all around tomorrow. If everybody would just go to work tomorrow, not for money.
Wake up.
But go to work just to give. And that's exactly how God's kingdom operates. That's how you receive something, by giving something. Because it's more blessed to give than to receive. And when you give without any conditions attached, in other words, free, that's when the 30, 60, 100-fold blessing comes.
All comes back to you, multiplied.
So we need more people to start operating on a kingdom principle. But yet nobody's thinking, how do we operate without money? How do I go out and buy a piece of land without paying money for it? How do I buy my groceries without money? But see, that's kind of like this concept. You think you have to buy your groceries. No. How do they get the groceries into the store?
From the farms.
Yeah, the farm. Now, everybody doesn't have to live on a farm. We don't have to go back to farms, everybody. But everything came from a farm. But you could do a garden in your backyard. And if there's a vacant lot next to you, you could ask the guy, hey, I'll use that ground, take care of it for you. You won't have to mow the grass, and I'll keep it picked up. If I can plant a garden in there, I'll give you, say, 10% of the proceeds out of that at harvest time.
Yes, most people go for that.
Now, let's go one step farther. Let's not talk about an exchange or a barter there. Let's just say, I'll let you use the ground because I'm not using it. And if that's what possession is because of use, that's real ownership as to possessory title. If I'm not using the ground, then how can I say that I possess it? And I should let you use it because I'm not using it.
So you said we're just trustees for God of the land.
Yeah, in the old days we used to stake 4 stakes in the ground and say, okay, this is mine, and go record the claim. And what is the claim that you're recording? You wrote down what you did. I drove 4 stakes in the ground, and I claim this is mine. In other words, I'm using this within the 4 stakes. And you created a record, which is, you call it a deed, and you recorded that, made it public. You made public your private act, which you did. So was it the piece of paper recorded in the county? That's the deed? No. It's the act of driving 4 stakes in it saying I'm using the property. I'm using the property. So really, title today is nothing more than a use of possession. If you're not using the ground, you can't possess it. If you don't use the ground, you're not possessing it.
Yeah, definitely a totally different way of looking at that. Yeah.
God told Adam, hey, go tend the garden. Go use it.
Back to Eden, huh?
Yes. Let's go back to a kingdom where there's no commercial venue, where everything is free. And everybody gives to one another because you have a need for it. and I got an abundance of it. In fact, I grow an abundance of it just to give it to you. This is like
Right.
unthinkable. So I know it is. It goes against man's thinking.
Right. It's like totally opposite. Like you said, if you're growing, you have an abundance because you always have more than enough when you're growing it. Right. I just thought that was interesting. So thanks for elaborating on that.
Anything else?
Yeah, I got a DC question. You like to keep this on equity, but you talked before, like for mortgage, and if you did a mortgage and they didn't record the deed, they didn't put the trust in the deed, the deed in the trust within 90 days. If they can't do it, they can't do it after that time, and they can never do it.
Yeah,
so I've been
securitization mortgage, securitization.
Right.
Yeah, the IRS has set rules that it has to be put into trust the way the prospectus is laid out, or else it can't be a pass-through and an arm's length deal. And it can't have the tax exemption. And then if it goes past the date, you can't go back and do it, ever.
Okay, so hypothetically, I have a situation like that where it's way past the 90 days, and help somebody, and
they can't go back and say, "Well, we'll put it do it the right way." No, it's gone past the date. There's no do-over dates. There was probably a grace clause in there of a certain time. I think 30 days.
After the 90 days.
Yeah, it's 60 days plus 30. That's 90.
Gotcha. Okay. 90 total. Gotcha. Okay.
If it wasn't done, then it don't have tax-exempt status. And what's that mean?
So I gotta pay those taxes.
Yeah.
Mm-hmm. But I mean, the banks are still. I mean, in a lot of instances, they're still, even though that didn't happen, they're still trying to come after the homeowner via foreclosure. So.
Yeah, through some servicer that doesn't even know that the trust is not valid.
Correct.
They're just believing the bank when it says, "Hey, we own this property, foreclose it. We own the mortgage."
Gotcha.
Here's the $1,250 to do this case. Oh, by the way, here we have another block of 50. Here, take them.
So in that case, it's just a matter of asking them to, they take you to court, just asking them to produce the trust and the certificate numbers, I guess. Just.
If we would persecute or prosecute those that were doing the wrong and everybody that was touching it, it's like the driver of the getaway car in the bank robbery.
Uh-huh.
Well, he didn't rob the bank. Yeah, but you were the driver of the getaway car. You're just as guilty as the rest.
So the original lender, he's really guilty when, even though he's passed it on to the servicer, like, hey, go do this.
Yeah, so you servicers, did you check out the fact whether or not they really were who they say they were? Otherwise, you're just as guilty as them. And you need to pay the fines and the fees and the damages and everything else.
Right. Because the servicers actually bring the court action. I'm sorry, I didn't hear you, Christian.
They're tied in with the act, and because they didn't do their due diligence, doesn't let them off the hook.
All right. Well, I remember you saying that. I just wanted to get a little clarification, and you kind of clarified that for me as well. So.
Yeah, it's got to be
Appreciate it.
on the prospectus, however the date is.
You said
They call that what is it, the closing date and there's another two terms. I forget what the other one is. Cutoff date. Closing date, cutoff date.
you said that's in the perspective?
Yeah, that's in the prospectus, yeah.
Closing date and cutoff date. Well, I mean, hypothetically, this happened like in September, and then they didn't try to do anything as far as like trying to record the trust until the next year in June. So, I mean, that's a long period of time. So.
Yeah, usually 2 years after they do the securitization, they usually file the 15D.
Right. All right. Well, hypothetically, we went through a couple of like two different securitization audits trying to find the trust, and you can't find it. So I'm thinking that there is no trust. So,
Well, there may have been a hypothetical trust that was set up, a master pool with all these different notes supposed to be in it.
Right. So hypothetically, in this instance, it's a REMIC.
Right.
It's a REMIC pass-through pool. So I think that's exactly what you're explaining here.
Yeah, the pass-through. Yeah, the pool.
Right.
Like one pool with many notes in it. But the question is, were the notes transferred the way the prospectus says it's supposed to be to make it a valid trust?
Gotcha.
But there's nobody making a claim for the trust. There's nobody bringing up any claims that the trusts aren't valid or any counterclaims. Especially if you've got a trust that's got a filed 15D, which D stands for dissolution. Trust is dissolved.
I thought it was dissolved, dissolution. Okay.
There's all kinds of stuff people can do out there. They just don't know. Just like Hosea says, they're perishing for a lack of knowledge.
Our people perish for lack of knowledge. Right?
That's their fault. That's my fault. That's our fault. And that's kind of what we're doing here. We're just teaching everybody knowledge so they're not hoodwinked.
Yep. Enlighten everybody to the equity jurisdiction and revival equity, as you say.
Yeah, that's where the real man needs to be in equity, not in the fiction court system, not in D.C. land. He shouldn't be signing contracts. You sign contracts, do business by contracts, you're doing business in fiction land. You're in Oz. You're in commerce. Trust doesn't operate under commerce. Purely private trust operates solely in equity, private equity. That's more operating under a kingdom of God than anything else. Equity is the God-conscious mind. Well, anything else?
That's it for tonight. Appreciate it and appreciate everything you and your wife do, and God continue to bless both of you all. Thank you.
Okay, thanks for coming on, Chris.
All right.
Okay, who's next? Anybody? Clear boards? Star 8, anybody? Question? Star 8? Anybody have a question? Press star 8. I guess we'll count them down. Star 8, anybody? Going once. Star 8, anybody?
Hey, Christian, it's Chris again.
Yeah. Mm-hmm.
You were talking about earlier saying somebody that got a public and a private side, and it made me think about hypothetically my situation with social security account, and hypothetically contacting the head of Social Security. But now you mentioned there's somebody on the public side, somebody on the private side, and I'm kind of wondering, would that the head person be the same person, or is it somebody else, but potentially that I may need to contact on the private side with my documents?
Well, that's, how would I explain that? That's like, I really don't know if I want to explain that. Let's put it that way.
Okay. All right. Okay. That's good. That's good. Maybe I'm.
In other words, how do you tie the two realms together?
How you tie the two realms together? Okay.
Like, give me the names of the titles in the two realms.
Name of the titles of the two realms.
Yeah, just think about it.
Okay. Okay. All right. Well, at least that gives me something more to think about and kind of. All right. I think I might be on the right path there. But maybe it's more, a little bit more to it. Okay. Good enough.
Anything else?
Thanks. Yeah, that's it. Thanks.
Okay. Anybody? Star 8. Question? Star 8. Anybody? Question? Star 8 going once. Anybody? Question? Star 8. Press Star 8. Star 8 going twice. Star 8. Last call. Star 8 3 times. Okay. It's like kind of made a full circle. I don't think people on the call really understand what we're doing, what it's all about, and the only reason you're going to get it is if you go back and listen to the top 30 audios and go back to the time we started November 9th, 2009. What NTT was all about. You know, NTT, how does that tie in with equity? I don't think anybody gets it. But that's just the sign of the times. But anyway. There's no question. Nobody's understanding. Everybody thinks it's too hard. It's really not. It's just that the learning in your mind totally has to be chucked out. It's a whole different system of reasoning that has to be relearned, reprogrammed. And there's a lot that's been written, and a lot of it is confusing in a way as to because it's talking about the same thing over and over and over again. And people just don't get the basic principles. And it really comes back down to the basic principles being equity. The equity maxims. I mean, we've got through a lot of books, and, you know, I see it myself. It's constant repetition of the same stuff and over and over and over and over and over again. And the same thing being said maybe from a different author's perspective, but yet it's still the same stuff. And most people don't have the in-depth study to support any kind of questions to be asking. There's no fine wine before the time. This is not a microwave fix. This is a whole revival of a whole jurisdiction that's been ignored for probably the last 100 years. It's where your real substantive rights are. And if you're not there in equity, you don't have any rights. And then you wonder why you don't have any rights. The at-law jurisdiction is where you shouldn't be. But that's where everybody chooses to play. And whether they see the light or not, that's not up to me. I'm just a crier in the wilderness. So I guess we got somebody on the board, so caller, you're unmuted.
Yes, Kristen, this is Jerome on Kentucky.
Yeah. How you doing?
I was pretty good. I was looking at the trust by Edward C. Hallback Jr. There's a 2007. Is that the newest version, or was it 2008? Do I have the correct one?
I forget what the one that we were doing, what the date on it was.
'Cause I'm only seeing a 2000 paperback and a 2007. But I thought you said 2008. I wasn't for sure.
I'm trying to look at the one I have.
Okay.
The one I have that I did all my readings and stuff from, that was a 2008 copyright edition.
Okay. Okay. All right. Well, thanks. That was my question. If there's no one else on the line, I'd like to ask one other question.
Yeah, sure. Go ahead.
I had a mortgage servicer recently. Bank of America sold or did the little transfer, and now we have another servicer. When they made the switch, we just did not make any payments or sign any paperwork with the new servicer. But they continue to send paperwork, but they haven't did any foreclosure, any legal documents, or any certified mailings. Should I just continue to go as if, we don't have a contract with them, or is there something I should do instead of just ignoring them?
Yeah, I wouldn't ignore them. I would put them on notice that they have to prove up documents of how they became the servicer. I want to see evidence that they are the servicer before I talk to you.
Correct. Okay.
And if they can't produce any documents, then, they're not the servicer.
That's true. That's very true. Okay. Well,
it's the record that I would create that I gave them notice that would have stopped them from moving forward. Because if they took it into the court and did a foreclosure, I could bring that in and say that they didn't answer these questions that I wanted to prove up that they were the servicer.
Okay. Let's see. I understand that. Okay. Okay. That'll work.
That kind of fits in with the UCC, what we did, the 9-210, the request for the verification of the accounts, basically. Same thing.
Then would there be verification or validation? I hear disputes are the two terms.
You could put it both ways.
Okay.
If you verify that you are the servicer, then you need to validate also the account.
That's it. Okay. 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 Well, that was my only question, and I'll get off in case there's another caller. I appreciate your time, Kristen, and thanks for everything you're doing.
Okay. All right. Appreciate it. Thanks for coming on.
Thank you.
Nobody? So I guess we're going to call it a night. So, all right. Well, I thank you all for coming, and we'll see you next week, next Wednesday, same time, same channel. Everybody have a great week. Night all.